All right, folks, we are gearing up for one of the first big trials coming up in 2021. Take a look at these four former Minneapolis police officers. You've seen them before, all facing charges in connection with the death of George Floyd. Well, George Floyd died in police custody after one of those officers, Derek Chauvin, had his knee on the neck of Mr. Floyd for more than 8 minutes while George Floyd was saying he could not breathe. All of that back in May. Well, now, March 8th is the date the world will be watching as this trial is set to begin. March 8th, our cameras inside that courtroom. You will see and hear all the testimony, all the evidence. Court TV, gavel-to-gavel coverage. March 8th. It all starts March 8th, 9 a.m. But wait 1 second. Not so fast. 2 of those 4 officers have now filed court papers saying, maybe we don't try this case March 8th. Maybe we have a little bit of a delay here. We'll push it off. Maybe the summer, maybe a little bit later. Why is the question, right? Why? Let's bring in Court TV anchor Michael Ayala. Michael, what is going on here? March 8th, the world is ready to see and hear all the evidence and wait for this jury to reach some sort of a verdict in the case that has impacted the world. What's going on?
All right, you're right, Vinny. Not so fast, right? Both Derek Chauvin and Tou Thao filed motions earlier this week seeking more time to prepare for trial. Now, they're alleging extensive delays by prosecutors in turning over important discovery documents that threaten their right, or at least they claim threatens their right, to a fair trial. Now, Thao is asking for the trial to be moved from March 8th to July 5th. Chauvin's attorney asked for more time, but does not name a date certain. Now, Tao's motion goes so far as to ask the court to have the state pay for the defense costs associated with the delays, because he says the delays are intentional. And they both argue that the late documents should be inadmissible as per a previous court order. Now, the court set a date of August 14th, and documents have been rolling in as late as November 24th. So that makes up the 4 months that Thao is asking for. But the timing isn't the only problem, Vinny. The vast amount and the manner in which the documents are being turned over is also causing problems. Now, according to the motions, attorneys for both defendants lay out several issues regarding that. Number one, there's over 15,000 pages that have come in, 300 gigabytes of information that have been received after the deadline. Discovery turned over, it's been in flash drives, PDF files, and compact discs. That alone should be sanctioned, right? Most files are not searchable. That means there's no discernible order and they can't figure the order out. The information has been, in their words, haystacked or shuffled like a deck of cards. So important information is hidden inside other information that's completely useless. So that's caused problems. They say paralegals have spent over 100 hours trying to organize the material, and that the prosecution has over 60 law enforcement personnel on the case, numerous attorneys, including attorneys pro hoc vice. Again, we've come across this a couple of times. They're coming from other jurisdictions. So, Vinny, you can see why they are asking for more time. But the situation may also present an opportunity. I spoke with Joe Tamburino. He's a defense attorney out in Minneapolis, and he kind of finds the whole situation odd and thinks perhaps the defense should consider pressing on with the original court date. Let's listen.
Usually in a high-profile case like this, where you have the Attorney General himself involved, a prosecution team of 8 or 9 people, I believe it's up to, no, this is not common. Normally in a case like this, you would get all of your discovery, whether it's 10,000 pages or 30,000 pages, and it would be starting on page 1, going up to page 30,000, and things would be in order. This is professional courtesy. Both sides do it that way. So it's not common at all. It can only be one of 2 things. Number one is it's intentional, meaning that they want to create disarray and confusion for the defense. So that could be. Or it could be number 2, which is it's sloppy. The prosecution team is not ready for trial. And think about that. We're 9 weeks away from this trial. The biggest trial in Minnesota history, the first time ever in Minnesota that a felony trial will be live televised. The whole nation and world will be watching. and the prosecution team is handing over this type of discovery, when you have that kind of problem going on, you might strike while the iron's hot from the defense and say, we're going straight to trial. Because if they can't get their act together by now and it's 9 weeks from trial, you might as well do it.
It makes a lot of sense, Vinny, but it doesn't seem that the defense is going to take that route. But it is an interesting idea. And one final issue, Vinny, both defendants are also asking for more time to disclose the experts they will use at trial. Why? Chauvin claims, due to the global profile of the case, they're having a hard time retaining experts. So just issue upon issue upon issue.
I could see that, right? An expert comes in. I don't want to be the person, who's testifying for the defendants here. I mean, the lawyers, I think they kind of understand it. That's what they do. But, people are worried. This is interesting. This reminds me so much of like the civil practice of law, right? Where things get nasty and petty. And I've seen that done before in the exchange of documents. And back in the old days, right, before things were digital, right, you'd send a stack of just papers that are all out of order. Here, you want your discovery? Here it is. Boom. So it's getting nasty. Now, that's not the only thing going on here, though, right? There's another allegation against prosecutors perhaps holding something back and handing over some information, important information, a little bit late.
Yeah, that's right, Vinny. Tao, he raises another issue in his filing. He claims that prosecutors withheld important exculpatory information from the defense. His attorneys claim that the prosecution was aware of an FBI summary, we've talked about it here on our air, of an interview that they did with Hennepin County Medical Examiner Dr. Andrew Baker. And then they didn't turn it over until October 14th, which was 6 weeks after receiving it in violation, again, of that original court order. Now, according to the motion in that summary, the FBI write that, here I quote, Dr. Baker defined the mechanism of death as Floyd's heart and lungs stop due to combined effects of his health problems, as well as the exertion and restraint involved in Floyd's interaction with the police, and here's the important part, prior to being on the ground. Now, for obvious reasons, this is important, and Tao claims that the delay was intentional because if the defense had had this at the probable cause hearing back in September, he might have prevailed and there might not even be a trial. But of course, I want to remind everyone that Dr. Baker's original report was in fact delivered to the defense on August 24th.
Yeah, this is such a big part of this case, and I don't think we've talked about it. We've talked about it here, but I think we're going to need to talk about it a lot more because it gets to the whole cause of death issue, which the defense is going to fight here. And from that little summary from the FBI, that completely excludes Chauvin's knee on George Floyd's neck.
That's right.
That's like game over.
Yeah, I mean, it really becomes an issue of this question of but for, but for the actions of Chauvin, but for the actions of the officers and aiding, abetting in Chauvin's actions, would he be dead? But is it a but for? I don't know if it's necessarily a but for, Vinny. It's did it aid in the death? And clearly in the original report by the doctor, it says that. So it just might be an error. But of course, the defense attorneys are going to jump all over. It's going to be a major, major issue at trial.
Yeah. I just have one short question. Dr. Michael Baden performed the autopsy for the family. Mm-hmm. Do you think prosecutors will call him because his opinion will be stronger than their own state employee?
I think that's a tough call because he has a completely different view of the death here. Now, it's clear in Dr. Baker's writings that he didn't think that the knee on the neck had anything to do with suffocating him or causing a blockage to his airway, and he cites a number of reasons, whereas Dr. Bodden thinks that that was the cause. So that's going to be a tough question for prosecutors. I think if you're going to call your own medical examiner, which I think you kind of have to do, then you can't call Dr. Bodden.
Wow. What a case. Yeah. Unbelievable. Michael Ayala, thank you so much.
You're welcome.